Recording in progress.
It is Tuesday, September 2nd at 6 p.m. Call this meeting of the Washoe County Planning Commission to order. Could I have a determination of quorum, please?
Jim Barnes.
Here.
Michael Flick.
Here.
Linda Kennedy.
Here.
Dan Lazareski.
Here.
Amy Owens.
Present.
Rob Pierce.
Present.
And Commissioner Nelson will not be here. She has an excused absence. So we do have a quorum.
Thank you. Please join me in the Pledge of Allegiance. Thank you. Could we have the ethics law announcement and instructions for public comment?
Jen Gustafson for the record. Commissioners are reminded that if with respect to any matter or any person coming before the commission today, number one, you've received a gift or loan. Number two, you have a pecuniary interest. Number three, you have a commitment in a private capacity such as a family, employment, business, or similar relationship. Or number four, if you've provided representation or counseling before an agency to a person or entity for compensation within the last year on a matter being considered here tonight, please remember to disclose that gift, loan, interest, commitment, or prior representation at the time the matter is being considered. And furthermore, please remember that you must abstain from deliberation or voting on the matter if it's clear that the gift, loan, interest, commitment, or prior representation would materially affect the independence of judgment of a reasonable person. Commissioners are also reminded that under your Planning Commission rules, if you've had any contact outside this meeting with any persons interested in a matter coming before the Commission today, you should disclose the nature of that contact at this meeting. I'm also going to go ahead and read the Zoom instructions. The meeting is being held tonight in the County Commission chambers and also via Zoom. To attend the meeting via Zoom, you can log into the Zoom webinar using the link found on the first page of the agenda. You can also join the meeting by typing zoom.us into your computer browser, click Join a Meeting on the Zoom website, and enter meeting ID 842-7265-9406. If anyone has any technical difficulties tonight, you can join the meeting via telephone only by dialing 1-669-900-9128 and enter meeting ID 842-7265-9406 and press pound. For those wishing to provide public comment via Zoom, you can utilize the raise hand feature during any public comment period. And to provide public comment via telephone only, you can press *9 to raise your hand and *6 to mute or unmute. Thank you.
Thank you. Mr. Lloyd, would you read the appeals procedure?
Yes, most decisions rendered by the Planning Commission are appealable to the Board of County Commissioners. If you disagree with the decision of the Planning Commission and you qualify as an aggrieved person or party, you may appeal in writing within 10 calendar days from the date that the decision being appealed is reduced to writing, filed with the Secretary of the Planning Commission, and mailed to the original applicant in the proceeding being appealed in accordance with Washoe County Code. Please call the planning staff immediately at 775-328-6100 for information on the appeal procedure and the application fee.
Thank you. Item 5 on our agenda is public comment. Do we have any public comment at this time?
I have no public comment at this time in chambers or on Zoom.
Thank you very much. Has the whole board had the chance to review the agenda for tonight? Do we have any comments on that? All right, I move to approve the September 2nd agenda as written. Could I get a second?
This is Rob. I'll second it.
All those in favor?
Aye.
Any opposed? Motion carries unanimously. Has everyone been able to review the August 5th draft minutes? Do we have any notes on that?
I move we approve the minutes as written.
This is Rob. I'll second it.
Thank you very much. All those in favor?
Aye.
Any opposed? All right, we're on to public hearings. Item 8A, abandonment case number WAB 25-0005 for Cheryl Lane. Mr. Lloyd, could you announce?
All right, this is item 8A, abandonment case number WAB 25-0005 for hearing, discussion, and possible action to approve an abandonment of Washoe County's interest in 3 access and public utility easements as follows. 1, a 33-foot wide foot wide easement on the western property line of the parcel. 2, a 33-foot wide easement on part of the eastern property line of the parcel, and 3, a 66-foot wide easement in the southern portion of the parcel. Representing Washoe County in this matter is Planner Julie Olander.
Good evening, Julie Olander for the record. As Mr. Lloyd said, this is an abandonment for Cheryl Lane, and as he read off the request, it's for 2 33-foot wide easements and a 66-foot wide easement. And just to get you oriented, this is where the easements are located on this parcel off of Toll Road. And then, oops. Oh my gosh. Am I going the wrong? Okay. And here's a map showing where the easements are. So there's one along the west side, the east side, and then the lower southern portion of the parcel, and that's a 66-foot wide parcel easement. And I just want to point out also on this map that the parcel will be in the left side of this map, has a 40-foot wide easement on that parcel. So you have 2 easements on this parcel for sure, 2 easements showing on this map for Cheryl Lane, one on the one that's being asked to be abandoned, and the other one is on the adjacent property owners or parcel. So as I said, there's 2 easements involved, the 33-foot easement on the east and the 66-foot wide easement along the southern portion. And both those easements don't provide any access to neighboring parcels. There's access established on other roadways, and I'll show you in just a moment, versus on other roads, including Rocky Vista Road, Rocky Vista Court, Big Smoky Drive, Sylvester Road, and Hot Springs Road. And here's a map showing those roadways. So you can see that the easements on the east and the south really don't provide any access to the neighboring parcels. They all have access. They all have established access versus via other roadways. However, the 33-foot wide easement along Cheryl does provide access to the parcel to the south of the applicant's parcel. And you can sort of see it's just below that yellow circle. And that, as I said, there's that 40-foot wide easement on the adjacent parcel. So we have that 73-foot wide easement for Cheryl Lane, which is significantly wide. Cheryl Lane is just a dirt road. However, all of the Cheryl Lane existing roadway is located on the adjacent parcels. On the adjacent parcel. None of it is located on the applicant's parcel. And then also, as that little yellow circle shows, it sort of takes a jog. You can sort of see where the road is. The purple line is where the road should be located, going down the middle of both parcels. However, that's not exactly where it's located. And then it takes a jog down there where that yellow circle is, and it's going on to BLM property. And that's not legal. That jog should be staying on where Cheryl Lane easement is and not on the BLM property. And here's some pictures. So again, you can see the road on the top left picture. That roadway is totally on the adjacent parcel. Where the trees are is the neighboring parcel that's asking for this abandonment. And there's sort of 3 different shots of the picture going up Cheryl, and then at the top on the right side, and then on that lower left is the end of Cheryl Lane. It's been gated. Even though Cheryl Lane does go through through the adjoining parcel. There's a gate there. So, and it's fairly steep. It's not really accessible. I tried to drive over and tried to get a picture of the other portion of Sherrill, and I don't know if any of you were able to go out there, and it's not very accessible. So staff is recommending a partial abandonment of this request. Staff is in favor of the 33-foot wide easement along the eastern property and the 66-foot wide easement along the southern portion. However, along the western portion, we're recommending a 13-foot wide easement, so that would preserve a 20-foot wide portion on Sherrill Lane on the applicant's parcel. Also, as I stated in my staff report, there is a AT&T and NV Energy easement along there, and we are only asking for abandonment of Washoe County's interests, not the utility easements. And AT&T asked that we preserve the easement, and I did speak to them, and I believe that email is included in your staff report, that they were in agreement with the 13-foot wide abandonment, however, not the 33-foot wide abandonment. Abutting properties owners were noticed. I did receive several phone calls. I did not receive any emails. Some of the neighbors, one of the neighbors did come into the department and spoke to me directly, again, concerning that 33-foot wide easement along the western property, that they were not in favor of that. And I explained to them at that time staff was proposing only a 13-foot wide abandonment. Various agencies did review this application, and their comments are included in the staff report, and agencies with conditions are in the conditions of approval. Staff can make all the findings as explained in the staff report, and I have a possible motion. Also, the applicant is here and can answer any questions, and I don't know if they have a presentation per se, but they can speak to any of the questions you might have, and I'm available for any questions. Thank you.
Thank you. Does the applicant wish to make a presentation on this?
My name is James Darrow.
Sir, you got to come up to the microphone because we have to record you for the record. Thank you.
Excuse me.
Oh, you're fine.
My name is James Darrow. I'm the land surveyor working with the owner, Walt Husted. His wife is here, Amy, and they concur with the planning department's staff recommendations. We don't have any comment other than the goal was to originally try to get rid of that, but the owner understands that there's utilities there also, so he's willing to concur with the recommendations of the staff, and we have no presentation.
Thank you. Does anyone on the board have questions for staff or the applicant? Do we have any public comment on this item?
I have no public comment in chambers. I have no hands raised on Zoom.
All right. Any discussion or deliberations on this item? If not, I'm happy to hear a motion.
Commissioner Kennedy moves that after giving reasoned consideration to the information contained in the staff report and information received during the staff presentation, the Washoe County Planning Commission acknowledge the re-recording of the resolution and order of abandonment with correct documentation numbers, and to correct the title of the easement from a construction easement to a slope. Am I reading the right one? To a slope. What? Am I reading the right one?
I don't think that's.
No, that's not the correct one.
It's not the right one.
Should be 8A, WAB 25000.
Commissioner
not reading
Kennedy,
the
we're
right
going
one.
to put up
I'm
on the
sorry.
screen. We're going to put it up on the screen.
Someone
for you.
else should jump in here.
All right, I'll get it. This is Rob. I move that after giving reasoned consideration of the information contained in the staff report and information received during the public hearing, the Washoe County Planning Commission partially approve abandonment case number WAB 25-0005 for Walter B. the Fifth, I think, and Amy Husted, retaining a 20-foot wide access and public utility easement along the western property boundary of the subject parcel, and with the conditions included in Exhibit A in the matter, having made all three findings in accordance with Washoe County Code Section 110.806.20.
Thank you. Do I have a second?
Chairman.
Yeah.
Second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? The motion carries unanimously. Thank you. On to our public hearing, item 8B.
Okay, this is amendment of conditions, case number WAC 250010 for St. James Village, TM 5-2-92. For hearing, discussion, and possible action to approve an amendment of conditions for tentative subdivision map, case number TM 5-2-92, to remove 3 parcels from the St. James Village tentative map that total 224.1 acres that were cut off from the project when the I-580 freeway was constructed. This request will also result in a reduced total unit count for the St. James Village tentative subdivision map from 510 lots to 450 lots. The parcels to be removed have the following APN: 046-060-45, 046-060-47, and 046-080-40. Representing Washoe County in this matter is Senior Planner Chris Bronzik.
Good evening. Chris Bronzik, Washoe County Planning. So we're looking at WAC 250010. This is for St. James Village, which had the original case number of TM 5-2-92. So it's a request to approve an amendment of conditions for an existing tentative subdivision map, St. James Village, to remove 3 large parcels from the existing St. James Village tentative map that total 224 acres. As mentioned, these were cut off from the I-580 construction that completed in 2012. So the St. James Village subdivision as a whole is located within the forest planning area. With the cutoff of 580, these 3 parcels are located actually in the South Valleys planning area. It's located east of I-580, and ultimately these parcels are going to be part of a new subdivision. So there's a lot of background associated with this, and I'm not going to go too heavy into it. The main importance is that this project has gone through various amendment of conditions to amend their conditions and get extensions to keep the map alive and bring it before you to remove these parcels. The most recent one was in December of 2023. So the removal of these 3 parcels removes the allowed density by 76 units. The applicant is proposing a reduction of 80 total units. And so this is a map of the proposed Sierra Reflections subdivision and the existing St. James subdivision. And so that red highlighted area are the 3 parcels that are proposed to be removed from the St. James Village tentative subdivision map. So property owners were noticed within 1,500 feet of the site. 66 property owners total were noticed, and because it's an amendment of conditions, there's no neighborhood meeting required. Staff was able to make all of the required findings, and we are recommending approval with conditions. I've got a possible motion for you on the screen. I'm available for any questions you may have.
Thank you. Did the applicant have a presentation? Or no?
I noticed that the map is supposed to expire on October 16th, 2025. Are they going to be coming back in here to get another extension?
Thank you for the question, and through the chair, yes, the applicants have submitted an application for a development agreement through Washoe County, which is scheduled to be heard by the county commission for the proposed extension of time. It will not come back to the planning commission. That will go directly to the county commission.
Okay. Thank you.
Did the applicant have a presentation to make?
The applicant does not have a presentation, but is present if you have any questions.
All right, and just to clarify, Mr. Bronzik, since Sierra Reflections came up a couple times in the presentation, what's before us today is not in any way an approval of Sierra Reflections. It's just removing land from St. James Village plan.
So bringing up Sierra Reflections is being transparent about what's being proposed, but overall, what's being heard today is just the removal of those 3 parcels from St. James Village tentative map. It does not include any sort of anything related to Sierra Reflections beyond that removal.
All right, thank you. Any other questions from the commission for staff or the applicant? Do we have any public comment on this item?
I have no public comment in chambers. I have no hands raised on Zoom.
All right, any discussion, deliberation, or a motion?
This is Rob. I'll make a motion. I move that after given reasoned consideration and information contained in the staff.
Hold on. Oh, it looks like we do have some public. Do you want to make public comment? This is your last chance. Come on. Go ahead. I'm sorry. Chair, can we reopen public comment? They got their heads up late.
Absolutely. We'll reopen public comment. Please approach the mic and state your name for the record. And
Thank you.
give your
My
comment.
name is Sandy Kellums. I live off of Kitts Way down in Pleasant Valley. And questions on this, what they want to do here. Are any of those properties bordering any current City of Reno properties with the 3 lots that they want to change?
Ma'am, this is your opportunity for public testimony. It's not a time for questions and answers, so you can provide comment or ask the staff that question afterwards. But yeah, it's not a time for you to ask questions of the Planning Commission unless they wish afterwards to ask staff that question. So feel free to provide any testimony or comment that you have at this time.
Okay, well, my comment is that we all know, sitting here, that Sierra Reflections, even though they state that they have no plans of bringing those 3 properties into Sierra Reflections, we can all be pretty certain that they do indeed have plans of bringing that into Sierra Reflections and increasing the density out there, which is, for those of us who live out there, we are all opposed against that. And so I guess that's all I get to say, is that we are opposed against allowing this, because we know that the density is going to be transferred into Sierra Reflections. And it's already too much out there.
Thank you.
So, where does that leave us?
Ma'am, does that conclude your public comment?
Yes.
Thank you so much.
We need you to come over and fill out a public comment sheet, please. Thank you. Appreciate it.
It looks like we have more public comment. Yes, state your name for the record. And
Michelle Torino. Also live out in Washoe Valley, and I just ask that you guys consider all us residents that moved out there because we didn't want to be in the city. You consider our water, and please do not let this be a Mount Rose condos and stuff. We live out on the edge of the county of Washoe to be in the country. And I just ask that you think of our water. We don't want city water. We don't want to be on sewage or on septic. And just please consider our values and not let somebody with deep pockets get what they want. That's all. Thank you.
Thanks very much. Go ahead and fill out a comment card, too. Is that the end of public comment on this item?
I don't see any further public comment in chambers, and I do not have any hands raised on Zoom.
All right, well, I'm going to close public comment again and take it back to the board. Go ahead.
Okay. We are just removing this property from St. James Village, correct?
That's what's before us today, Mr. Lloyd.
We are not changing it to something else, right?
That's correct. But there would be nothing that would prohibit these parcels from being used for something else.
What are they currently zoned for? What's their current zoning?
They're all split zoned with open space, general rural, low-density suburban, and medium-density suburban.
So that's in place today.
Correct.
And by us taking them out of the St. James Village group doesn't change that.
Correct.
Okay, thank you.
All right, any further discussion by the board? Would we like to take another crack at a motion?
Go ahead. I'm confused.
Then ask.
Mr. Chairman, okay, so the density remains the same on the 3 parcels. And yet, by taking this action, they're reducing the density on the St. James or on this other one?
They're reducing the approved unit count of St. James Village.
So they're reducing that
They're
subdivision
taking
by
80
lots.
units out of the St. James plan.
Okay. And I think one of the questions is that 80 lot density reduction going to be able to be carried over to the 3 parcels that are being separated and included in the other subdivision?
Mr. Lloyd, would you?
Yes, I will answer that question. Yes. What's happening is the applicant has asked to remove all 3 parcels and reduce the amount of density allowed within the existing St. James Village by 80 lots. The actual amount of density associated with those 3 lots is less than 80. It's 75 lots of density. But that can be used with another development. It is no longer, with your action tonight, it will no longer be associated with the St. James Village development.
Okay, and if I can follow up, then the owners, whoever they may be, now the applicant and somebody else in the future, if they sell it, they could either, if the current owners maintain it, they can go ahead and probably incorporate it in the other subdivision.
Currently, there is not an entitlement for another subdivision, but there is a proposal. And that is the plan, yes, to utilize density from these 3 lots with future development.
With the future development
Yes.
that hasn't been submitted yet.
It's right, it's in, well,
Review?
it will be coming forward to this planning commission in the not-too-distant future, I'll put it that
Okay.
way.
So-
And that's, excuse me, so that's in the county.
Yes.
And if they sold that piece, somebody else could go there and put it in, apply for a new subdivision and get the 70-plus lots. And that would not be a part of the pending application. And the other question was concerning Reno. We have nothing to do with Reno, actually.
There are no plans by the city of Reno to extend this far south. You have to go back in time about 20 years, and there was plans. However, that whole concept is no longer on the table. And as far as I'm aware, there are no plans by the city of Reno for annexation to extend this far south.
So Reno would have to apply for annexation of those 3 parcels. There's a whole litany of bureaucracy to go through on that before they would be able to have control over that piece. So the control remains here until or if that happens. Okay.
So
Thank
I
you.
want to ask another question. So the people who voiced their concern for increased density in this property is really not relevant to this decision. It may be relevant to the decision when the property owners come forward when they ask for the new use of this property. Is that correct?
In part. Yeah, an increase in density is in no way part of the request before you tonight. And if the owners decided to develop the neighboring property that this will now become part of, that, in order to change the density, it would require changing the zoning. And as far as I'm aware, there is no request to change the zoning to increase the density. So all of the existing zoning that is currently in place, my understanding is it's the applicant's intent to utilize that current zoning, that current density.
Okay. So our motion is just to take it out of the St. James Village, period. And it has nothing to do with a change in density.
That is correct. It is also to change the lot count of St. James Village to match the removal of the 3 lots.
Okay, thank you.
One more question. You bring up a good point. Since we haven't really seen the application, we don't know, but with the addition of these 3 parcels, does that add to obviously it adds to the configuration of what this new development application is going to look like, but does it give them enough acreage to plan more efficient lot design so it's overall the development gets more density?
Well, I think, and Chris, you may want to put that graphic that you had on the overhead.
Jen Gustafson for the record. I just want to clarify for the board, though, that we are not here to be deliberating on a project that is not currently before the board. And we are not, here to be making any judgments about future projects which are not currently being presented to you.
I understand.
No more public comment after the deliberation.
So there is a public comment period at the very end of the meeting, sir. So what you see, what Chris has on the overhead, it's generally a layout of St. James Village to the west. And for all transparency, Chris has also included what is intended to be submitted to Washoe County for future development. But as legal counsel indicated, the purpose of tonight's meeting is not to litigate an item that is not before you.
Okay.
That's true, but the concern of the residents in the area, and I'm sympathetic to that, is by adding more land, can they reconfigure the existing configuration that they're showing and yield more lots? That's a question I don't know, and the attorney basically saying it's none of my business right now.
To yield more lots, it would require upzoning. It would require rezoning the properties to increase the established density. So, and that is not on the table tonight.
Okay. And plus you got to take in topography and everything else in the thing. Okay, that's about as close as I can get.
All right. I would just like to bring us back around to the fact that this development originally dates from 1992, where 33 years later, this was planned with the original footprint and unit count based on no one had even proposed constructing I-580 through the middle of it. And so we're looking at the proposal before us tonight is about properties that were really orphaned by that NDOT development from the community that they are on paper a part of. So it makes a lot of sense to me. Specifically what's proposed for us tonight, taking these 3 parcels out of St. James Village.
Are you ready for a motion?
And do we have further discussion?
Any further discussion?
I'm talking up a storm tonight. You have any projected construction date or pulling permits or finalizing the maps?
Good evening. For the record, my name is Ken Crater. I'm the applicant on this project. And as Trevor mentioned, this has to do with St. James Village and not Sierra Reflections, right? And we will be coming forward, as Trevor said, in the very near future with full presentation on the other projects. We can get into all those questions then, but clearly tonight, this is just to deal with the fact that the freeway cut that land off from St. James Village. It would never make sense for the homeowners association to have to govern that land on the other side of the freeway. There's no real good way to access that. But I can say that, as Trevor mentioned, we're actually decreasing the unit count even more than we need to in St. James Village, right? The density allowed is 76. We're taking 80 units away, so we're actually getting rid of 4 more units, which is a decrease in overall density. But you'll have the full chance to see the Sierra Reflections project, full presentation, and I can also state that we've done at least 3 neighborhood meetings to date. So we're being very transparent with the community about what our plans are on that project. Hopefully that answers your question.
Thank you.
You're welcome.
All right, and respectfully, Commissioner Fleck, I'd like to remind the board, after we've taken closed public comment, we're really just deliberating. We're not further inquiring to the applicant. Any further deliberations from the board? Do we have a motion?
Commissioner Kennedy would like to move that after giving reasoned consideration to the information contained in the staff report and information received during the public hearing, the Washoe County Planning Commission approve amendment of conditions case number WAC 25-0010 for St. James Village, Inc., with the previously approved conditions included as Exhibit A to this matter, having made all 10 findings in accordance with Washoe County Code Section 110.608.25.
I'll second it.
I have a motion and second. All those in favor?
Aye.
Any opposed? The motion carries unanimously. Mr. Lloyd, would you like to read the appeal procedure again?
Let me turn that on. Most decisions rendered by the Planning Commission are appealable to the Board of County Commissioners. If you disagree with the decision of the Planning Commission and qualify as an aggrieved person or party, you may appeal in writing within 10 calendar days from the date that the decision being appealed is reduced to writing, filed with the Secretary of the Planning Commission, and mailed to the original applicant in the proceeding being appealed in accordance with Washoe County Code. Please call the planning staff immediately at 775-328-6100 for information on the appeal procedure and the application fee.
Thank you. Item 8C, public hearing for amendment of conditions for continuum of care.
Okay. This is an amendment of conditions, case number WAC 250014, for hearing, discussion, and possible action to approve an amendment of conditions for special use permit WSUP 220001 and tentative subdivision map, case number WTM 22001, to amend condition of approval 1Z8 in order to change the requirement that at least one occupant of each resident be 62 years or older. The proposed modification provides that at least 80% of the occupied residences must be occupied by at least one person who is 55 years or older. And representing Washoe County in this matter, once again, is Planner Julie Olander.
Good evening again. So as Trevor read this off, he told you, I'm not going to read this part because he already just read this, so I'm going to move on. So I just want to get you oriented to where the location is. It's out off of Neighborhood Way. So this was a tentative map and a special use permit that came in for this development. And one of the and the special use permit was for continuum of care, and that was required per our use table, and then also included major grading. And then the tentative map was to create 136 lots on 21 acres. So what the applicants now come in to change this one condition, which we had stated one occupant of the one of the residents must be 62 years or older. And the applicant is wanting to follow this new federal guideline, which basically states that 80% of all the residents in the development have to be 55 years or older. So this makes it a little more flexible for the HOA and the applicant in a sense. It allows for residents to have spouses that are younger than 55 years old, or domestic partners or dependents. So kids could be living with their parents. And then also additionally would allow the HOA to have people live on site that they would deem necessary. So property owners within 500 feet were noticed. 46 notices were sent out. I did not receive any emails or phone calls concerning this amendment. Various agencies reviewed the application, and their comments are included in your staff reports and any with conditions of approval. However, I think planning's the only one that has any changes to the conditions are in the conditions of approval. And then staff can make all the findings, and I provide a possible motion. Also, the applicant's available for any questions you might have, and I'm also available for any questions.
Thank you very much. Do we have any questions from the board for staff or the applicant? Hearing none, do we have any public comment on this item?
I have no public comment in chambers. I have no hands raised on Zoom.
Do we have any deliberation? If not, I'm happy to hear a motion.
Rob, I'll make a motion. I move that after giving reason and consideration of the information contained in the staff report and information received during the public hearing, the Washoe County Planning Commission approve amendment of conditions case number WAC 25-0014 for the Silverado Village Eagle Canyon LLC to modify conditions of approval 1Z and 8, with the conditions included in Exhibit A to this matter having made all the findings in accordance with Washoe County Code Section 110.810.30 and 110.608.25.
Commissioner Owens for a second.
All those in favor?
Aye.
Any opposed? The motion carries unanimously. We are on to item 8D, regulatory amendment for Marengo Springs.
All right. As for hearing, discussion, and possible action to recommend adoption of a regulatory zone amendment to the South Valley's regulatory zone map to change the zoning on 4 parcels totaling 80 acres as follows. 35.5 acres located at 18090 Marengo Road from low-density rural to medium-density rural, and 9.7 acres located over all 4 parcels, APN 17-4-10-60, 55-7-1, 24, 25, and 26 from general rural to open space. The existing MDR regulatory zoning over 34.7 acres located on the 3 parcels, 050, 571, 24, 25, and 26 will remain. And if approved, authorize the chair to sign a resolution to this effect. And representing Washoe County again is Planner Julie Olander.
Julie Olander for the record. So as Mr. Lloyd explained, this is a regulatory zone for 4 parcels, and we're asking to change the zoning on one of the parcels, 35 acres, from low-density rural to medium-density rural, and then all of the parcels that have GR on them, all 4 parcels have some GR on them, and that is being requested to change to open space. There's existing MDR zoning on 34.7 acres on the 3 parcels, and that will remain. So here's a picture sort of showing what you've got. So on the left is the existing, and you can see that the larger parcel is going to, on the larger parcel, all the zoning is going to change from, the proposal is to change it from LDR to MDR, and then the GR section on there to OS. And then on the 3 lower parcels, the GR section that sort of is in the middle of the 3 parcels to change to OS, open space. So all these parcels are off of Marengo Road and have a master plan designation of either rural residential, that's where the MDR and LDR will be is located, and rural designation, and that's where the GR is located. And as I said, the 35 acres is proposed to change to MDR on that one larger parcel, and that will change the density from 1 unit per 5 acres to 1 dwelling unit per 8 acres. So there's an increase of density. This change will allow for 7 units on the 35-acre parcel versus 4 units when it was LDR. So there, like I say, an increase. The 3 parcels, southern parcels already are zoned MDR. So the MDR is already in that location. The applicant states that this would still keep the quiet rural feel of the area and still with the proximity of the city and the mountains. And then again, that change of the 9.7 acres, that's GR, would change to OS. The OS is limiting on any kind of residential zoning, residential uses. So right now on GR, you could have a house on the GR portion. The OS does not allow that. And here's just some pictures that the applicant included in their application. It's a little hard to visualize it, but you can sort of see the one parcel on the left is sort of looking towards Marengo Road, and the picture, the photo on the right is looking south away from Marengo Road. Just concerning water and septic, these parcels are not within areas where they can be connected either to community or community water or community sewer. All the parcels will have to have domestic wells and will need to be developed with on-site septic systems. And the applicant will have to work with Washoe County and Nevada state engineer concerning the wells, and then also with Nevada Northern Nevada Public Health to develop the wells and the septic systems. They held a neighborhood meeting on June 26 at the South Valley Library. There were a total of 13 members of the public that were at the meeting. They had questions about the additional wells and septic, stormwater drainage, traffic on Toll Road, fire risk mitigation, and that they asked for the power lines to be underground. The public asked questions for over 40 minutes, and comments were primarily about more homes in the area, the impacts of those homes, bringing in more people in the area, fires and other emergencies in the area, and the lack of roads to manage that traffic exiting the area. Property owners within 750 feet were noticed of this zone change. 49 parcels were noticed. I did receive, as I put this presentation together, one email, but I received another email this afternoon with the petition in it. I believe you all got that. And then the legal ad was put in the Reno Gazette 10 days before the public hearing. Oops. I don't know what happened here. Oh, no, getting it back. Various agencies have reviewed this application. None of them recommended denial. And that's included in your staff report, and then staff can make all the findings as I explained in my staff report. I have a possible motion is in the staff report, and the applicant's representative is available for any questions. I'm available for any questions.
Thank you very much. Do we have any questions for staff or the applicant from the board? I'd like to open public comment on this item. Do we have any public comment?
I have no public comment in chambers. I do have one hand raised on Zoom. Sue Moritz, please unmute. State your first and last name for the record.
It's Sue and Jim Moritz. We're just following up on the questions that were already there, but just the concern about not having city water and septic. You know, we all are on wells, and a lot of us are on our last leg as far as being able to re-drill our wells. So if the water table drops, we'd have to start fresh and re-drill all new wells. And the last well that was put in this area went 500 feet down. So obviously concern for us. We've had a number of fires in that location. Several houses have been burned down in the Ramona Road area from a previous Andrews fire. At that point, we found out that the evacuation routes were very constrained, one way in, one way out. And that obviously with emergency vehicles and other things of that nature caused a pretty concerning traffic jam at that time. So we would hope that a secondary road would be placed in along with underground electric lines so that we don't have to worry about wind issues knocking down the lines and starting another fire or a fire. And then in the new development, maybe adding fire hydrants so that in the case of a fire, we could actually fight the fire with hydrants instead of aerial, which was done last time with choppers and bombers. So that's all our questions or concerns. Thank you.
Thank you. Is that all for public comment?
I have no further public comment online or in chambers.
All right. Do we have any deliberation by the board?
Comment. I have concerns about increasing the density when there's no information about water availability, sewage availability, and increasing density, and they've also expressed concerns about increased traffic in this rural area. So I'm very concerned, and I don't see any reason to increase the density that they've come up with. I don't see any reason to do this.
All right. Commissioner Flake.
It seems density is one of the issues, and I'm a little confused on the density change. If you could go over that again for me, please. I'm a little slow today. So the current density for the large parcel is what today?
So Julie Olander for the record. So currently the LDR allows 5 units per acre. Excuse me, 1 unit per 8 acres, and the new density would allow 5 units per acre. So the LDR is 1 unit per acre, and there's 35 acres basically there. So that would increase the density to allow. So that's, I don't have my math. So right now the LDR would allow.
So if I could clarify, LDR allows 1 unit
per 8
acres.
So
MDR that they're requesting to increase allows 1 unit per 5 acres or 4?
It's 5 acres. It's a little confusing because MDR allows 4-acre lot sizes with a density of 1 per 5 acres.
All right. So in the 35 acres at issue with the upzoning, ignoring that we're going from 4 units allowed to 7 units allowed.
Yeah.
Correct. So overall, you're looking at an increase of 3
units.
3 lots total.
And
what are the other 3?
So on this parcel, the other parcels already have MDR on them, so they're not being increased. So those parcels at the south, maybe we could put the map back up.
the other change is just from general rural to open space on the riparian
that's no
corridor
big
and
deal.
steep hill down the center of the parcels that's otherwise unbuildable.
Well, it could be buildable. I mean, there are parts that they could be buildable. So the OS does prohibit that, so that takes away any possibility of those areas being developed. So you can sort of see that the lower portion, the 3 lower parcels already have that bright yellow on them, and that's not changing. So the only thing that's changing in the lower 3 is where the GR is, that's going to OS, open space, which does not allow any residential. Currently, it does allow some residential, and I don't want to say it's not buildable. It's possible they could put units there. So that's just something to hold on to. And then the northern parcel is LDR right now. They are allowed 4 units. They'll be allowed 7 units. So it's an increase of 3 units. And it's, so it's still, the lots will still have to be basically 5 acres,
All right, because the minimum lot size is 4 acres.
but the density is 5.
Yeah, I get it, okay. So,
Do you have any pictures of that area?
Yes, there were those pictures I had included there. Oops. No, I'm going the wrong way, sorry. It is hilly there, you know, it's not flat property by any means. It's sort of, that's the reason these pictures are sort of difficult to look at, but you can sort of see that there's, and that's just a drainage area in the middle. It's not a running, it's not a stream or anything like that. It's just a drainage area.
And where would the open area be on those pictures?
Primarily down in that drainage area is where it's at.
so when you gather all, when we gather all the lots, all the acreage together, what is the total yield today?
So on the only parcels that is proposed to have its zone change that would allow residential is right now it allows 4 units, and it would be increased to 7 units. That 35.
Yes.
That's the only parcel that's changing the zoning on it. The other parcels are just changing from a GR to OS. In a sense, those other parcels are possibly losing some density. So there can be less houses on those 3 lower lots going to OS. So that portion could be decreasing the density. I didn't calculate out, it's only 9 acres, so it's about, I'm not sure, I didn't break it down to how many acres were in each parcel, but it's not, a lot, but it is something.
Open space can't be built on directly, but it can be included in a parcel that's an otherwise residential parcel, correct?
Yes, yeah.
Open space cannot be built on the open space, but there is a distinction where we don't have any minimum lot size for open space where you do for GR. And so part of the reason, I think having open space provides a little more flexity in the lot layout, lot design ultimately that the applicants are looking for. So in that way, it makes sense. But there's no density associated with open space, and there is no minimum lot size either.
So what does that mean? That means that they have to come here to see if they can get 1 or 2 lots out of it, or no?
If most likely what they would do is submit for a parcel map application, which would go to the parcel map review committee.
But the still minimum is 4 acres.
4 acre minimum lot size is correct.
So when they go for, which is not in front of us tonight, but just to clarify, when someone goes for a parcel remap that includes creating additional residential parcels that have an entitlement to drill a residential well to serve themselves, they have to go out and get water rights to serve that additional parcel. That's correct?
Yeah, any additional parcel that's created would require acquisition of additional water rights, yes. And so what you can anticipate at this location is well and septic, not community water, not community sewer. Right. And let me take back one statement I made earlier. If they're asking for 5 or more lots, which is possible, no?
Well, they could ask for 5 or more lots on the larger parcel. The 3 lower parcels are only about 13 acres each.
But what I was getting at, it could come back to this planning commission with a tentative subdivision map. So that's up to
on
you.
the 35-acre parcel. Right. Well, it's really 40 acres, excuse me. It's 35 that's got the LDR on it currently, and then there's about 5 acres that has GR on it right now.
If it's under the same ownership, they could go ahead and submit a tentative application for a tentative map for all 4 parcels.
Not,
The big one and the three little ones.
So, as Trevor said, if you create more than 4 parcels, it becomes a tentative map, correct? I'm sorry, yes, I think that's what you were saying, Commissioner Fleck, yes. So then if they wanted to do that, they would come, if on all 4 parcels, they would have to come in for a tentative subdivision map.
Okay.
But if they just were dividing one of the parcels, it would, the 3 lower ones would just qualify parcel
And
maps.
that map would have each parcel on, it has to be a minimum of 4 acres on the tentative map.
That is correct.
Okay. Okay. I'm good.
Any further deliberation by the board? If not, do we have a motion?
This is Rob. I'll make another motion. I move that after giving reasoned consideration and information contained in the staff report and information received during the public hearing, the Planning Commission adopt a resolution and included in Exhibit A recommending adoption of regulatory zone amendment case number WRZA 25-0003, having made all of the following findings in accordance with Washoe County Code Section 110.821.15D. I further move to certify the resolution and the proposed regulatory zone amendment in WRZA 25-0003 as set forth in the staff report for submission to the Washoe County Board of County Commissioners, and authorize the chair to sign the resolution on behalf of the Washoe County Planning Commission.
I'll second it.
All right, I have a motion and a second. All those in favor? Aye. All those opposed?
Nay.
The motion carries. That is it for our public hearings. Closing them, move on to item 9A.
Hey, Julie, don't leave. I'm sorry, I don't mean to interrupt. I've got a question for you after. So, I'm sorry, go ahead.
Do we have any future agenda items? Any requests for information from staff? I have one, actually. We often see requests for small incremental upzoning in places that aren't served by community water systems. I understand that planning and the water resource staff at the county have their own process for identifying what resources are needed to increase unit count and what water rights qualify to serve an area. And if we could just get some kind of a memo or training or understanding of if we approve a unit somewhere, what kind of due diligence do they do to make sure that there is sufficient water to serve that unit?
Good idea.
All right, any other requests? Item 10A, do we have any reports on previous planning commission items?
Yeah, I have a few things to report on. At the August 26th BCC meeting, the county commission adopted the Tahoe area plan update and some upcoming meetings. The Board of County Commission is scheduled to hear the code amendment at 560 Lake Shore Drive. That's up in Tahoe on the September 9th meeting. Also on that meeting, they're scheduled to hear the MPA RZA at 700 Harper Court. And that's all I have to report on.
Thank you. Any updates from legal?
Nothing from me today. Thank you.
Thank you very much. That brings us to item 11, the final public comment period. Do we have any public comment?
I do not have any public comment in chambers, and I do not see a hand raised on Zoom.
All right, thank you very much. We are adjourned.
Interruption, boss. I just had to catch her before she ran out.
Excuse me, would you do me a
Recording stopped.